Institute. The topic which is assigned to me is about Indian judiciary and then role of Dr. Ambedkar and visualization of him, how he think about the judiciary. As Professor has rightly pointed out about the first amendment, constitutional amendment, which was carried out for the purpose of amending Article 15, that the judgment of the court is to be obeyed, but it's not binding on us to go with the respect of this very judgment. To map out the judiciary structure, it is spanning through the entire text of the Constitution in a way. Though it may not have been formally mentioned into the Fundamental Rights chapter or Part 3 of the Constitution, but Part 3 consisting of Article 13 starts with that thing that the laws are amenable to the review by the court. So about the judiciary, it's very tough to point out in a very straitjacket formula that this part only deals with the judiciary. It's not just the structural part of the judiciary which is supposed to be emphasized. And I would be like to add on the point about Dr. Ambedkar's views on that. I don't want to confine myself to the role of Dr. Ambedkar in the Constituent Assembly. Rather, he's being held as the main chief architect of the Indian Constitution. But I would like to add on that point that he is the chief architect of the Indian constitutional law. I'm making a difference between both of them. I'm not just contented with his role as a father of the Indian Constitution or the chief architect of the Indian Constitution. Rather, his role as the chief architect of the Indian constitutional law, which is everyday affecting the lives of the people. And being the Supreme Court being the last word into the interpretation of the Constitution, there is a tussle between the judiciary and the legislature on this point of being the last word, but there is there is no final settlement on this point that the judiciary alone will be. But as far as possible, it is mostly the interpretation which comes from the court, which would assume the position of the finality of the particular text of the Constitution. To which I would start with how the judiciary can be mapped out. Judiciary first to be mapped out from the role of the judicial review, which is very much conferred by Article 13 of the Indian Constitution on the Supreme Court of India. Article 13 clubbed with Article 32 as well as Article 226. I may sound little technical to many of the people here, but that is technicality which is inevitable in the course of dealing with the judiciary part. So the judicial review part, which has been the role which has been assigned to the Supreme Court, was to play a role like that of the conscience keeper of the Constitution. The Supreme Court was also given the role of protecting the Constitution. So we have to look into this aspect of the judiciary, how far the judiciary has been able or how far the judiciary has done its job very properly to keep the conscience of the Constitution intact, or even to allow the Constitution to grow in its in the sense of its normal growth, in the sense of the natural growth of the Constitution, as no Constitution can be a static one. So that is the first part of the judicial review which the court has been bestowed with to go with. And it's not the good start for the Supreme Court when it started functioning in the year of 1951. So like the case of State of Madras versus Champagam Dorirajan, to which this first constitutional amendment was referred to, the court could not realize that role which was assigned to the court by the Constitution of India. And it looked at the Constitution very technically as a kind of document carving out the state machinery alone. That is true that the Constitution is supposed to carve out the machinery of the state, that is the first, but that is not the end of the Constitution, that is just the beginning of the Constitution. It should deal with the composition of the state, its various organs and all that. But that technicality cannot be the shackles in the legs of the Supreme Court to transgress beyond the technicalities. And there are lots of ample of this possibilities, and the provisional wise there are possibilities of this interpretation which court can easily resort to, but it all depends on the judges who are sitting on the bench. How do they look at the particular fact circumstances? How do they look at the laws which are made on the demands of the people, or which are made on taking care of certain social evils to be taken care of? So that first part which I would like to speak about the judicial review. Second thing, Professor Dr. Sukhdev Rosa has rightly pointed out about the unified judiciary in a federal system. Whether the Constitution of India is a federal or not is a very debatable question always. But what Dr. Ambedkar had thought about the federal constitution or federal features in the Constitution. Constitution of India is not completely devoid of the federal features of the Constitution as such, but the emphasis is not on the federation. the emphasis is on the union, as it was very rightly pointed out in the morning session. The emphasis is on the union. We are not like even, I would say that we are not even the United States of India. I may be corrected, but when I say it is United States of India, I am giving the feeling that the states were already independent. Now they are coming into the union, this unity, and therefore they are United States of India. This is the phraseology used by the American Constitution, United States of America, because they were originally the independent states. Hence, they have to use that terminology, and for very right reason, this terminology is avoided in the Constitution directly. The Article 1st has used that one, that Union of the State, Union of India, instead of the United States of India. So that is one technical part of the United States of India, or like calling it as. And therein the role of the Supreme Court, being a very like this kind of dual polity. Dr. Ambedkar always tried to avoid using the federation, rather he used to prefer to call it as a dual polity. We have dual polity as well as this. Then coming to the judiciary, it should not be with that dual system as it exists in the United States of America. What is the difficulty with having the different system in the state wise? Because they will have like different laws to be operated, different laws to be interpreted by the different set of the legislature, and there would be like growth of the law would be like curtailed, or it will be like confused rather. If it is not curtailed, it would make a lots of confusion. On this point, the judiciary as carved out in the Constitution of India is unified one, but with a very unique feature of distinction, about the High Court's role. High Court is not again said to be like under the administrative control of the Supreme Court of India. It is not. The constitutional scheme is that way. Though it is one singular unified judicial system, but the system is not making the High Court as subordinate to that of the Supreme Court. Supreme Court is at par with its capacity when it comes to the matter of enforcement of the fundamental rights. Their decisions are like as that of the Supreme Court. Therefore, there are technical rules in the Constitution of India how to appeal over the judgment of the High Court. Rather, the judgments of the High Court are not directly appealable, even if it is a matter of fundamental right. So therefore, the part of the judiciary comes in play. So here, on the point of this unified system, when it was being debated in the Constituent Assembly, this was very rightly pointed out by Dr. Ambedkar that we want to have this unified system, but that unified system would not like to suppress the powers of the High Court. The High Courts would also coexist with the Supreme Court and with that unified. And that's why I am calling it as a unique feature of the Indian Constitution, a very, very salient kind of the feature of the Indian Constitution. Second part I would like to highlight about the judiciary is about the appointments of the Supreme Court and High Court judges. That is again said to be a unified one. It is very true. But here comes the difficulties about the appointment of the judges of the Supreme Court and High Court, as it was discussed in the Constitution Assembly, that the appointment would be done by the President of India alone on the consultation of the Chief Justice of India. So here the role of the Chief Justice of India and the President of India has been a matter of contention before the Supreme Court judgments. Many of them are there. The recent one is from the year of 2015. Therein the court has quoted Dr. Ambedkar largely. And this point I am trying to highlight. Dr. Ambedkar is just not invoked for the interpretation of the what was that provision. But now both the parties in this case of 2015 has invoked Dr. Ambedkar to say that the finality should rest with the President, and another set of argument was that the finality of the appointment of the judges should rest with the Chief Justice of India. So where to take the stand? To clarify on that point, to my knowledge and to my interpretation, whatever I could study, is that when it was being discussed whether the President would be binding, whether the President would bound to consult with the Chief Justice of India, and what was the weightage of that opinion of the Chief Justice of India to the President, then Dr. Ambedkar said that yes, the appointment shall finally rest with the President of India, but there has to be the respect to the opinions of the Chief Justice of India. That is the point. But the thing is that the way it is interpreted in landmark judgments of the Supreme Court, it has changed the constitutional position now. Though formal letters of appointment come from the President of India, but they are in fact, in theory, appointed by the Chief Justice of India alone. Alone in the sense collegium system, through the collegium system. But completely a kind of change into the constitutional scheme has been done. And the point is that for this change also the court is invoking Dr. Ambedkar. And another point is also that those who are wanting to stall this change and wanting to roll back onto the constitutional position, they are also invoking Dr. Ambedkar. So that's a tough thing to go with, how to read Dr. Ambedkar in different contexts. And this thing is happening in many other areas of his contribution. About judicial appointment also this has happened. Again, about the amendment of the constitution, I would say, the role assigned to the Supreme Court, though Article 368 do not refer to the role of the Supreme Court as such, but being a very basic theory of the constitution itself, whenever there is a written constitution, it automatically gives the power to the court to interpret the constitution. So in the case of amendment of the constitution also, the court has got that power to review the amendment of the constitution. So that how the court has used that power to amend the constitution, the court has used the power to review the amendment of the constitution is a great matter of research and debate also and critique also. But from the very single word from Article 368, which has to be emphasized here also for your knowledge as well, the that single word is amendment. The amendment itself indicates that it is an amendment, means a formal change, not kind of topsy-turvy change of the constitution. It has to change. A constitution is a living document, constitution is a growing document. It has to change according to time. But that change doesn't mean like complete transformation, a complete kind of topsy-turvy situation. That gives the scope to the court to interpret to do the review of the constitutional amendment. But how far is another question. How far the court should go into that, that is a real question. Court should do that, but the question really is how far the court should do that. I would quote like a comparative analysis of this thing about German constitution. German constitutional court, which is at par with like that of the Supreme Court of India, is also empowered with this same power, that they can review the amendment of the constitution. But what do they do in the practice? The practice is like that if the amendment is there, the court will adhere to that amendment, will say that yes, this amendment, we respect the amendment, and ask the government to like go with that. And if any change is suggested, they would like asking the government to go with the change. But they will not straight away strike down the constitutional amendment, which is not the case in India. The court is directly going to strike down the constitutional amendment. The German court do refer back that kind of amendment with the observation to the system, like to the legislature. And if it is not still done, on the second occasion, it can be struck down. So that is the legitimacy of the power to be used. Thank you. There are many points about this, but I would like to conclude with the one remark by Justice V.R. Krishna here. The role assigned to the Supreme Court is a very great role when it comes to the matter of the interpretation of the Constitution, fundamental rights, fundamental duties, and directive principles of state policy. The role of the court should be little biased. I may shock to some of you, but this is not my word. These are the words of Justice Krishna here. He said that judges must be biased. Biased positively, biased towards the marginalized. They must be able to realize the pain of the people and think that way. And otherwise also it is not possible to have a judge who is completely unbiased. Biasness is a very natural phenomena. It comes with every person, even if it is a Supreme Court judge. So the role of the court should be in that sense. The role of the court to further the objectives of the Constitution. And Constitution for me, or I would quote Professor Upendra Bakshi for this point, the Constitution is only preamble of the Constitution of India. The rest of the Constitution is running as a very long footnote of the Constitution, from starting with Article 1 to Article 395 and all the schedules there too. The basic Constitution rests in the preamble of the Constitution, and which needs to be adhered to and which needs to be respected to, even by the judiciary also, while they are interpreting the Constitution. With this, I take your leave. Thank you.